The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome, counsel, and to all of those who are watching us on our Supreme Court Live channel. We look forward to our arguments today in this afternoon's case. I will now ask Mr. Doug Shima to please call the docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Friday, February 5th, 2021 consists of one case. Appeal number 118379, Hugh Michael Hawkins versus Southwest Kansas Co-op Service and Travelers Indemnity Company. Workers' compensation case, briefs both sides. The appellee petitioner has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. We now ask counsel if you would please state your appearances.
May it please the court, and good afternoon. I'm Bill Townsley. I represent Southwest Cooperative and Travelers Insurance. We're present and ready for argument.
May it please the court, Scott Mann on behalf of Hugh Michael Hawkins, the appellant, and we are ready for argument.
Thank you, counsel. Mr. Townsley, you may begin.
Thank you very much. Again, may it please the court and counsel, this is an appeal from the Court of Appeals regarding a workers' compensation case. Specifically, the case concerns subrogation rights of an employer following a third-party claim. Here, Hugh Hawkins, the claimant, worked for Southwest Cooperative on November 8th of 2006. He and a coworker fell 70 feet when a rented boom crane failed, and they suffered very serious injuries. Travelers was a workers' compensation and carrier for Southwest Cooperative. And over time, it paid $852,000 in medical benefits, and which included $125,000 in permanent total disability. Subsequently, Mr. Hawkins filed civil lawsuits against 3 entities. The crane manufacturer, which was Western Steel. There was a subsequent owner of the crane, United Rental, and then finally JLG or Manitex, which is the subsequent owner of the crane. In 2008, the plaintiff settled with Western Steel for $925,000. That was all apportioned to loss of consortium and loss of marital services. Subsequently, plaintiff settled with JLG Manitex. That was $1.5 million to be paid over a period of 20 years. And subsequent to that, there was a jury trial left with only really the one defendant, United Rentals. The jury found no fault to United Rentals. It apportioned 25% of the fault to Southwest Co-op and 75% to Western Steel. It awarded a total of a little over $4 million in damages. Subsequently, in the workers' compensation court, there was a hearing to determine the amount of the subrogation lien. The administrative law judge found the lien was $477,000 and a future credit existed of $272,000. That was appealed by both parties for various reasons, and in the Court of Appeals reached a decision in which it imported the jury verdict from the United Rentals case and applied it to the JLG settlement. This appeal is followed, and we found 3 issues on appeal that we've raised. First, we contend that the Court of Appeals erred when it applied a subsequent fault determination to an already entered final judgment so as to diminish that already attached lien on that initial judgment. Second, we contend the Court of Appeals erred when it considered using an uncollectible damage award, the jury verdict, in which there was no recovery, in using that in light of the plain meaning of recovery in the statute and the statutory scheme that provides for applying fault to recovery. And finally, we believe the Court of Appeals erred in holding that installment payments from a judgment are not recoveries until they are paid. Starting first with our first issue, our position is that the Court of Appeals decision eliminates the long-standing rule that a subrogation lien in workers' compensation automatically and immediately applies to a judgment. Here, the JLG judgment was a settlement agreement between the parties without trial. The statute provides that settlement agreements are recoveries the same as a jury verdict would be. And in fact, there are cases, including Moss versus Huxtable, in which parties have reached settlement agreements and applied comparative fault determinations within that settlement agreement. That didn't happen here, however. We believe that the decision reached by the Court of Appeals, in which it took a subsequent jury verdict, imported it back in time to a prior verdict or prior settlement in which there was no comparative fault, was error. And it leads to results that are anomalies and are inconsistent with the established law regarding subrogation.
Counselor, what should happen with the 25% fault that the jury found? Is it your position to just be ignored? It's not factored anywhere since it's subsequent to the settlement?
That's absolutely correct, Justice. It's apples and oranges, and that's going to be our point today. You apply the recovery from a specific event, you apply the comparative fault to that. Here, again, they've taken a comparative fault from a subsequent jury verdict in which there was no recovery, taken it back to JLG, the prior settlement in which there was no apportionment of fault, and that's significant. The effect of this, and there are a couple of factual issues that led to the Court of Appeals mistakes here. One, the Court of Appeals stated numerous times that that Travelers and Southwest Co-op had not exercised their statutory right to intervene, and as such, they lost their ability to preserve their statutory rights. In fact, that's not consistent. The Court of Appeals stated that, in particularly at page 21, the company that chose not to exercise its right to participate in the trial and thus to present evidence and argument guiding the jurors as to what would be viewed as the best result, having strategically elected to remain a phantom party in front of the jury, Southwest Kansas Co-op must now bear the consequences of its decision. In fact, Southwest Co-op was a party to the settlement with JLG and to the verdict in the jury trial. They were a plaintiff and they were represented by Mr. Mann. In that regard, the Court of Appeals was wrong also in mentioning Travelers as an entity that was represented by the same lawyers as Southwest Co-op and having the same interest. It wasn't. Southwest Co-op was represented by Mr. Mann in the settlement with JLG, and at that time they chose not to apportion any fault in that settlement agreement. This is no different than in the first settlement, in which was captioned differently. Southwest Co-op was not a plaintiff in that case. In that case, the plaintiff's counsel apportioned all of the recovery to loss of consortium and marital services, and the Court of Appeals notes that we groused about that. We recognize that there was no statutory intervention by Travelers or the employer there. That's gone, but it doesn't change the fact these are fictive decisions in which everyone in that room knows that when there's $1 million plus in damages, there's payment of $1 million, and it's apportioned entirely to loss of marital services. Everyone knows that the whole purpose for that is to defeat a subrogation lien. Fine. We understand that happened in that first settlement, and we go on. I don't like those judgments and those agreements, but that'll be my grousing.
Mr.
By the
Townsley,
same token here,
Mr. Townsley,
I'm sorry.
Mr. Townsley, let me, it seems to me we've got, you say 3 issues, and I think that's right. The first one is whether we take the 25% or reduce it to 0. And when I look at the statute, which subsection D, all it says is if the negligence of the employer is found to have contributed to the party's injury. That's all it says. It doesn't say it has to be found at the time the money is generated, or it doesn't say anything about the process of making that finding. So why can't the Workers' Compensation Board and the ALJ make that finding? You asked them to determine your lien and your lien reduction, and there's an administrative process here, and they chose the 25% jury determination. Why isn't that allowed under the statute?
Well, Judge, I think that's not a reasonable interpretation of the statute. I think you have to read Section B along with Section D. The critical portion there is in subsection B. It says, in the event of recovery from such other person. Here, there was, of course, no recovery from the jury trial. The recovery occurred from a prior settlement agreement and judgment with JLG. And Section B goes on to say the employer will be subrogated to the extent of compensation and medical aid provided by the employer to the date of such recovery. Again, the recovery was in advance of the jury trial. To me, it's nonsensical that you take a subsequent jury trial with different defendants, different parties, and then import it back in time to a settlement agreement, an agreement in which apportionment of fault could have been included if plaintiff chose to do so, and they didn't. So again, it's a matter of statutory construction in the cases that support that, and the Court of Appeals used State v. Jones. But the idea is that we try to have a reasonable construction of a statute to arrive at a reasonable result. This result will leave anomalies into the future, and there are many. For example, what happened if there was summary judgment and we didn't get to a jury trial? Then, of course, there would be no apportionment of fault. What if in the first settlement they apportioned fault at a different amount than they did in a subsequent jury trial with a different defendant? If that's different, what do you do? What if the damage amounts, and in the JLG judgment, they determined his damages were $7.3 million, not $4 million. Why not use that number?
Well, that's a different question. I'm focused on the 25% right now. I mean, I realize everybody wants to argue about each component of the mathematical formula. But right now, I'm just focused on the 25%.
Right.
And in all of those instances, why can't the Workers' Compensation Board determine what kind of a reduction should occur on your lien?
Well, and I think the board can determine that, but the point is, in our position is, it's just nonsensical to take a jury verdict with different parties, different defendants, and no recovery, and take it back to a judgment that's already final, that already has a lien attachment to it. Okay, so if we had this judgment, the first judgment, it was say $1 million, not $1.5 million, and there's a subrogation interest, and that's paid back to the employer, then, and I see I'm out of time. If with your permission, I'll finish this question.
Certainly.
Thank you. Okay, so if they've paid that, and then say the difference here was 3+ years between our first settlement and the jury trial, we get a jury trial with a different result. Well, what happens? Do you pay back what's already been paid one way or another? I mean, none of that makes sense, Justice Biles. What makes sense is that you apply a apportionment of fault to a recovered verdict, as it says in subsection B, in the event of recovery. To me, that only makes sense. So,
Can I, since we're close to out of time, let me walk you through a couple of things and just see if you agree with this. Let's assume we disagree with you and we're going to apply the 25%. And let's also assume we're going to apply it to the 1.5 million that represents the JLG settlement. Then you would agree that the most that you could have in your lien is $1,125,000, right?
Yeah, right, for both the subrogation lien and future credits.
But
Is that
that's the cap. That's going to be the cap of your
right?
of your lien. And so basically, I recognize you disagree getting there, but if you're stuck with it, you agree with the board's final determination there, the formula that the ALJ came up with at the end, which gave you the 852,000 and then said you had $272,000 still out there for future credits, right?
Right, although you didn't quite say it right, Justice Biles. The 852,000 is the amount of the lien. If you apportion the 25% to the $1,000,005 and subtract, you end up with a $479,000 subrogation lien and a $262,000 future credit. I think that the board or the ALJ used the infield formula appropriately. I'm not sure that I've addressed the other points. Again, our position is there are 3 issues on appeal, and I will wait till my rebuttal to respond.
I have a couple quick questions, Chief, if that's okay.
Certainly, yes.
I know you're out of time, so I'll try to make it quick. And I'll preface this by saying these may be dumb questions, I guess. But I'm looking at the subrogation statute 504. It looks to me like this entire statute presumes that the recovery is against a third party, right?
I agree.
So then here's what I want you to help me with. If you look in subsection D, what does it mean that a percentage, the percentage of the recovery attributed to the negligence of the employer? How do you get a recovery against a third party for negligence by the employer?
Well, in Justice Siegel, I take this to mean that, and this is how the infield court interpreted this, that you're taking in here, using this case, for example, the jury determined that Southwest Co-op was 25% at fault. What the infield formula would do, utilizing this, and this is what the Court of Appeals did, was apply the 25% to the total damage award, irrespective of the fact that it was there was no recovery, to reach this amount of a little over $1 million that established the amount of the percentage of recovery that's attributable to the employer. Does that make sense?
I'm not sure that it makes sense, but that may just be me.
Well, I agree with you that these are,
I'll just,
it's convoluted formula, and it's more convoluted in this case because of the facts at issue.
I'll just try one more time so I can understand maybe just the policy behind this. If a injured worker recovers money damages against a third party, those damages are already offset by comparative fault, correct?
Right? Or they could be.
Well, so I guess just from a policy perspective or a common sense perspective, why would the subrogation right be reduced further?
Well, and it's a good question. Subsection D was added by the legislature after the Negley case. In the Negley case, it illustrated that it was pejorative to a claimant to have a employer obtain subrogation for the damages it's paid, which would reduce the amount of the third-party award to the plaintiff that they'd be entitled to. So subsection D was added, and that was the statutory theory of recovery is what you've identified. The recovery is diminished by the percentage of recovery attributable to the negligence of the employer.
Let me just ask one more question. Isn't, in fact, the percentage of the recovery attributed to the negligence of the employer always zero? Because the recovery is never for the portion of fault that's attributed to the employer. Am I wrong about that?
Well, and I'm not sure I'm following you on that, Justice Stiegel.
You sue somebody and you're never going to get money from the third party for the fault of the employer.
Oh, I see what you're saying. No, you're right. You can't.
So the percentage is always zero. If we're talking about the percentage of the recovery is 100% attributed to the fault of the party that has to pay.
Well, and that's true, but let's look at this verdict. If it's a 25-75, then the amount of the verdict is going to be reduced by that comparative fault. So I guess you could say, it's always going to be zero for the employer if it's reduced. And of course, a workers' compensation claimant can't recover against the employer anyway. But I think that absolutely you can apply these percentages as it suggests in the statute. So probably didn't answer your question. Sorry for that.
No, you tried. I appreciate it. I probably took too much time. Thank you.
Are there other questions? All right, thank you, Mr. Townsley. Mr. Mann?
Justice, can I jump in and kind of try to answer the question you just brought up, that a recovery from a third party is inherently reduced already by the comparative fault of the employer? I think that's your question.
Yes, thank you.
Okay, and I'll just jump in on that. Okay, so you understand that the injured employee, in this case and in any case, cannot recover a civil judgment against the employer for their percentage of comparative fault for their damages. So let's just use this case. There are $4 million in damages. 25% of that was assigned against the employer, Southwest Co-op. The employee will never recover that $1 million in a civil action because of the exclusive remedy of the Workers' Compensation Act. So what we're trying to do, or what it actually came out in the Negley case, and I think the Negley case said it best. It's a Supreme Court decision in 1981. It is after comparative fault came out, but there was no reduction in the work comp lien for the employer's comparative fault. And in the Negley case, and this is on page 10 of the slip decision, it characterized a full subrogation recovery by a negligent employer as an unavoidable inequity necessitated by the language of KSA 44504B. So there was only section B giving the lien. There was no section D at that point giving the reduction. So let's apply B if there's no reduction to this case. My client has $4 million in damages. 25% of that is due to the employer. He's never going to recover $1 million civil judgment from the employer. He's only going to recover his work comp benefits, which at this point are only $854. He's maybe never going to recover the other $3 million, but let's say he did. Why should the employer get back anything if they've created $1 million in damages, but they've only paid $854,000 in work comp benefits?
Yes, thank you.
Why should they have any lien at all?
That does make sense. And I do understand that that's the intended policy behind the statute, and I appreciate your addressing my question. I'll just follow up and ask, I guess I'm asking whether subsection D actually accomplished what we might all agree was the intent. And the language I'm focused on is percentage of the recovery. If it said percentage of, the full judgment of damages, then that might make sense. But isn't a recovery the money that you actually receive?
I think the statute is ambiguous, and so I think it's incumbent upon the court to interpret the statute to fulfill the intent of the legislature. I've done work comp for 34 years. Unfortunately, the Work Comp Act is full of ambiguity. The court actually just addressed that in a recent decision of Howard Johnson. But I'm going to back up just a second because I think I can give some, I don't know, I can give you some history on this because I'm the one who litigated all of this. And Mr. Townsley was just on the work comp side, which is fine. But this crane was actually manufactured by JLG. It then was owned for a couple of years by U.S. Rentals. U.S. Rentals did some inspections on it, and then it was owned by the end user, Western Automation. And Western Automation owned the crane for like 10 years and failed to have it inspected at any point in time. The crane failed when the master cylinder burst because there were two extension cables that were crossed underneath it. The extension cables should have run parallel, but somebody had crossed them underneath it. And the moving of those cables rubbed against the cylinder. And unfortunately, when the master cylinder was fully extended with these gentlemen 75 feet in the air, it exploded, the boom reduced, dropped these two individuals. Litigation was initiated against JLG, the manufacturer, and Western Automation. At that time, it was not known about U.S. Rentals, but ultimately U.S. Rentals was added into the case. The case dragged on, and ultimately my client settled with Western Automation. So we settled with the end user for $925,000. We continued the lawsuit against the manufacturer, JLG, and U.S. Rentals. Right before trial, JLG disclosed that they had actually sold the crane line to a company called Manitex. Manitex arguably had no insurance coverage for this loss. So Manitex gave the plaintiff the option of entering into a judgment for $6.2 million if there was insurance coverage found, and there was an insurance coverage action pending in Texas. We had kind of an escape clause that if there was no insurance, if Manitex had no insurance for this loss, they could afford only to pay $75,000 a year for 20 years. Those payments are not guaranteed. If Manitex goes out of business, we won't get those payments. So far, we have received those payments. Of course, we didn't have an apportionment at fault at the time we settled with Manitex because we didn't want to apportion any fault to Manitex or any fault to the employer or any fault to the parties that had settled out. We wanted a jury to find that U.S. Rentals bore the majority of the fault. In going to trial, there was a strategy of bringing the employer in. So bringing Southwest Co-op in to explain to the jury $853,000 in medical bills have been paid by the employer. The employer wants their money back. Mr. Hawkins wants money for his future medical and his pain and suffering. And we think U.S. Rentals should pay all of that. So we were asking the court, the jury in this case, to find comparative fault on U.S. Rentals. We didn't want comparative fault against the employer, nor did we want comparative fault against any of the other phantom parties. The Judge Schrader, who's now on the Court of Appeals, deemed that the facts showed that the employer should be on the verdict form over our objection, over the plaintiff's objection, because again, any fault assigned to the employer, we're never going to recover. We're only going to get the work comp benefits. Long story short, we end up with a verdict. I only go through that history in that the settlement and the recovery from Manitex was never realized till far after the trial and until the coverage action was resolved. But again, we believe the Court of Appeals got this right. It all starts with Negley in that we are going to reduce the lien based on the damages caused by the employer because we cannot recover from the employer in the civil action. We can only recover from the employer in the work comp action. So the idea there is, why would the work comp carrier be able to recover monies from a third party settlement or trial or damages if in fact they cause damages that are not being realized in that settlement or judgment?
Mr. Mann,
Yes, I'm sorry.
I'm sorry to interrupt your closing part of that.
Okay.
I'm just curious how you respond to Mr. Townsley's position that the credit provision in subsection D has to be qualified by the language in subsection B in the event of recovery, and therefore any allocation based on a jury trial where there's no recovery is sort of a nullity.
I think it goes back to the intent of what are we trying to accomplish here, and there are some inconsistencies in that statute. But the bottom line is, Mr. Hawkins has not received any form of double recovery. He has $4 million in damages. Our judicial system isn't perfect, and ultimately he didn't recover all of his damages. But he has not recovered 25% of his damages from the employer. The employer has only paid $854,000 in work comp benefits, not $1 million and change. And so the intent is again to put both parties in a. I understand the lien process. If I receive work comp benefits and then I turn around and recover 100% of my loss from a third party, the employer should be reimbursed. I agree with that. And that's all we're trying to accomplish. If I don't recover 100% of my damages and fault is assigned to the employer for causing a portion of those damages, then they should not benefit from any settlement until I'm made whole. And that's what was accomplished by the Court of Appeals decision. It's well sounded in the case law we have, as well as that was the intent of the legislature. Again, going back to the Negley decision, it would be inequitable for travelers to get money back when they caused over $1 million of damages in this case. And we have a jury verdict that says that.
Mr. Mann, let me
Go ahead.
let me focus you. I think I understand. I think I understand the first two issues in this case, which is, do we use 25% or do we use 0? And then the second issue being, do we use 1.5 or do we use 4 million? I got that. I really am scratching my head on this third aspect, which came in from the Court of Appeals about the mechanics of the installment payments going forward and how to apply that lien that's on there and treating each payment, each $75,000 as an individual payment. And Mr. Townsley wanted to get to that point and we didn't let him, and I'm sure he'll swing back to it. But let me get your take on whether you think that's right or wrong, and then if so, what? Why?
Here's my thought on it, Justice. I think we can, I would submit that the damages are 4 million. The 25% credit is $1 million. Let's just use that number as the lien number. So until Southwest and Travelers pays $1 million. Okay.
I want to play like the number's $1.5 million and you got the 25%. And so you had $852,000 and now we've got another 272 coming. I want to know how to operate, what to do mechanically with the annual $75,000, making the assumption. I understand you've got the million and the 4. I understand that, but I want to know how to work the mechanics.
Well, my thought is this: until Southwest and Travelers pays workers' compensation benefits in the amount of the reduced lien. So in this case, the lien's being reduced. I'm using the 4 million and the million. So the lien's being reduced to $1 million. So until Travelers pays $1 million in work comp, there's no credit. After that, there's 100% credit because they've paid their fair share of the damages. And what's going to happen from a practical standpoint, although I don't think necessarily that's even before the court, because I don't know whether Travelers is going to have to pay another $250,000 in medical bills. They've already avoided paying medical bills since 2012 when they denied medical bills, and it's taken us this long to get in front of you. But going forward, after they've paid their fair share of the damages, $1 million, their portion of the damages, then they don't pay anything further, because theoretically I should be recovering that from other parties. So the whole point of trying to calculate this reduced credit in the future, that's not even necessary.
Okay.
Travelers limit on work comp is the amount of their reduced lien. That's the limit they have to pay.
Which would mean, hypothetically, and I know you don't agree with this, but hypothetically, if the board's correct about using the $1.5 million and the 25, after the 852, which we've already got documented, you would agree that every $75,000, 100% of that goes to Travelers until you get to $1,125,000, and then you get the rest.
Minus the attorney fees it took to collect all that money.
And I appreciate there's a sensitivity here of the issues and stuff, but that got raised. But that's the math of this thing, right?
It is. That would be inequitable because Travelers would be recovering money when they haven't paid their fair share of the damages under the Work Comp Act.
I got
And there's no civil remedy against them because of the exclusive remedy.
Right.
And frankly, that's not the intent of the statute.
Are there other questions? Thank you, Mr. Mann.
Thank you, Your Honor. Thank you, Justices.
Mr. Townsley, you reserve 3 minutes.
Thank you. Let me start with response to some of those comments. I hear Mr. Mann, and I've read his brief, how he's offended that Travelers is seeking money when they haven't paid their $1 million in damages. This gets back to the issue, what are our damages? The damages as found in the JLG settlement were over $7 million. It was $4 million in jury trial where there was no recovery whatsoever. And it bothers me that Mr. Mann, who's representing Southwest Co-op in this action, is now saying, well, they haven't paid their $1 million. And again, there is no recovery in that case. We have an opportunity to put common sense in play here. I cannot read this statute and conclude that somehow the jury verdict that happens weeks, months, or years after a judgment that's final goes backwards in time to change all of the liens that would have attached immediately and automatically to that first judgment. It just makes no sense at all. The application of the comparative fault, again, from a subsequent jury trial with different entities, different defendants. The first 2 entities who had settled weren't even in trial, but their fault was compared. Again, these are things that don't make sense. I can read the statute as well as anyone else. And sure, you can read subsection D say that doesn't specifically say, oh, this has to apply for each and every one. But again, it's apples to apples, oranges to oranges.
May I ask a question? And this just could be, this may be a dumb question. In subsection B, I mean, it talks about the employer shall be subrogated. And then you're saying that the lien attaches automatically at that point. A lien is created, but it uses the word subrogated. And then in subsection D, it also talks about the employer's subrogation interests. But it doesn't really talk about the lien. It just talks about subrogation. So could it be that there's a lien and then after that there is further subrogation?
Well, and just, I probably disagree, particularly in subsection B. It talks about subrogation, and it says that, line 3 of the statute, and you shall have a lien therefore against the entire amount of such recovery.
Right, but the first two sentences just say in the event of a recovery.
Right.
It just talks about subrogation. Then it talks about the lien. And then we go down to D and it talks about subrogation again. And you're just saying that I just understood your argument to be that, once a lien attaches, you can't really go back. But I just wondered whether that would make a difference.
Well, in workers' compensation, those liens do attach immediately. And so again, that's the anomaly of the Court of Appeals decision is that, again, if we've got a period of 3 or 4 years and those liens have been paid out in their entirety, and then we have a subsequent determination like this one, where we have parties not involved that are having fault assessed or not, do all the parties then go back and pay everything back? That just doesn't make sense. That's not, there's no continuity to that approach. Again, and that's the greatest flaw in this decision. And I'll add to you, this decision that Mr. Mann advocates, this $4 million verdict in which there was no recovery. The verdict actually awarded $2.5 million of those $4 million to Southwest Co-op. And so what in the effect is, then you're taking this $1 million of a 25% of it, but $2.5 million of that verdict was awarded to Southwest Co-op. And now we're saying we're going to still apply 25% against the amount it was awarded to subtract that. None of this makes sense. None of this makes sense. The fair reading of the statute and the facts here, with 3 recoveries over 3 years and payouts that have begun, would be that Travelers has an automatic lien to the JLG judgment. The first judgment against Western is, we can talk about equities or inequities. Clearly that went to the claimant because it was all loss of marital services, irrespective of the fact that what had actually been paid was medical and disability. And we get to this point that, again, it's a timing of when and what. And in this case, what makes sense is that there was no recovery from a jury verdict. Why would you apply that at all? Why would a subsequent jury verdict change a prior judgment, even if it came from a settlement? Again, those things do not make sense. So I see I'm out of time again. Just in conclusion, our position is the Court of Appeals decision should be reversed. There should be a decision that would establish consistency in a policy that's realistic into the future as it pertains to subrogation and workers' compensation. If so, then the JLG judgment should be attached for a subrogation lien with no fault assessed against any party, and the remainder of the $852,000 that has not been paid to date would act as a future credit in the event future medical is paid or needed by Mr. Hawkins. So again, we ask that you establish clarity with respect to subrogation and workers' compensation and reverse the Court of Appeals. Thank you very much.
Thank you. Any additional questions? Thank you both, counsel, for your arguments this afternoon. The court will take this appeal under